Okay. The last topic for the day is charge sheets and indictments. So what I would like to say is the charge sheet is used in lower courts. That's the first difference between the two. The charge sheet is used in the lower court, whereas the indictment is used in the high court. So the charge sheet or the charge is governed by Section 80 of the Criminal Procedure Act. Then the accused may examine the charge at any stage of the proceedings, and it informs him or her of what the allegations against him are. And normally they pay for the copies of the docket, but with regard to the copy of the charge sheet, they are not charged. So I think for now they are paying something like 150 per page or 2 rand per page. I stand to be corrected in terms of that. So the state has the right to amend the charge at any time before sentencing. But however, they have to bring this to the court's attention. Then the court will then have to decide as to whether will this be prejudicial to your client, or will this be to the best interest of the state's case. So, and there are certain requirements that needs to be met in the charge sheet. The charge sheet has to reflect who the accused person is, what is the offense he has committed, if possible, the time as well, and the place, when, the date, or the offense he has committed, as well as the course of action, what happened, causation. So this is very, very, very important as to the requirements, because should it then be then that the charge sheet doesn't specify some of the requirements that are to be met there, you can object and you can raise and not plead guilty to the charge, or you just exercise your right to remain silent. And then from there, seeing that your client hasn't even agreed to any of what the state's allegations are, then the court will then decide otherwise. But however, it's very, very crucial to bring it, to raise that objection, as to then say then that the reason why you are objecting to the charge, as I say, is governed by Section 85, this one, then it doesn't comply with the requirements of Section 84. It doesn't set out the essential elements of the offense. Let's say, for instance, theft. It has to be precisely to say when, what did he do, what did he steal, not just food. It must be like explicitly stated that by food I mean bread, spread, whatever, not encompassing everything. And then if on the other hand it doesn't disclose an offense, you can object to that as well. And if it does not contain sufficient particulars of the matter, or the person is not correctly named or described. And this is very, very, very important, because most of the time they will mess up with this part, whereby your client's name is not properly described, or he is not properly described. Then you can object to that. But then, however, the state, if the objection is raised, the prosecution can be given a chance to amend to the charge sheet in terms of a section 87, or in terms or request further particulars to clarify some of the things that were not properly explained. So take note of the objections, and then take note as well as to whether they are amendments. Then, other than that, there is a separation of trial. If, let's say, for instance, there is more than one person, let's say separation of charges, there is, example, one person who has who's facing different types of offenses, and then there will then be different people to be called to come and testify. The state may request charges to be stopped and then bring an application to court to have the charges separated. This is governed by Section 81, subsection 2 of the Criminal Procedure Act. And this is done before any evidence is led. And this, the court will then decide as to whether this is in the interest of justice, to then see if whether that can be done. So what normally happens, an example, if, let's say, for instance, your client is facing a murder charge or a rape charge at the High Court, and then he has another case at the regional court. He has another case, maybe he tried to escape from lawful custody. Then now the question is, where will this person then be prosecuted, or which court will then have to then go to? So the matter, what we normally say is, the matters don't go down, the matters go up, meaning the court that will have jurisdiction to listen to your client's cases will be the highest court. If, like in this instance, for all his matters, they will then be joined and face, let's say, 4 counts or 5 counts. But what will have to happen is he will then have to then go to the High Court to face everything. That is joinder of charges. But then if the matters have been joined and your client as well is not alone, so which means he has other people that he has been arrested with, then which means then such will then have to then be separated. So meaning he will have to then be, the other accused be removed from the matters where your client is with them. And as I said earlier, the test the court uses is, will this be in the interest of justice for such to be done? If yes, it's in the interest of justice for that to be done, such will then be proceeded with. And very much there's something that I would like to say with regard to the amendment to the charge. Take note that sometimes your client facing a charge of let's say possession of car or possession of suspected stolen items. Then during the trial, after consulting with the witnesses, the state can tell who the owner of the item stolen is. Then the state can bring it to your attention that, you know what, I'm going to bring an application for an amendment to the charge sheet whereby this will then be amended. And this can be amended at any time of the stages before judgment. So if the charge is defective, they want to amend that, they can do same. If they want to vary something or amend based on the evidence that is before them, the state as is dominus litis, they can still be given the opportunity to do so, only if it won't prejudice your client and a new offense is not created. It must be a continuation. Like for instance, in this instance, possession of suspected stolen items is not in dispute that your client was found in possession of this, not in dispute. It happened on that day. The only thing that was not known to the state was who the owner is. So it's not creating a new offense. However, it's just amending or varying or remedying the defects that are there in the charge sheet. And another important part, request for further particulars. This is in terms of section 87. This is very, very, very important. I once came across this, of which at the time I did not know of. That's when I started reading about it, whereby my client was facing a charge of culpable homicide. And I was scared to then say that, oh, culpable homicide, somebody died and whatever. I did not know. And we did appoint a pro bono advocate, and he requested further particulars. When he requested the further particulars, the state failed to produce that information to us. And they said, no, we are proceeding with trial and whatever. Then the advocate said, yes, let's go for it. And during on the day in question when the trial had to proceed, because this request application for further particulars must form part of the charge sheet, it was not there. The client was or charges against my client were withdrawn without even appearing, or not, he did appear without having to testify in court. So be wary of such technicalities, of which they are very important, and they can get your client scot-free. So the request for further particulars must be in writing to the state. Then the question that you ask yourself, is this necessary, will then be able to outline and define the issues that are in dispute. If yes, then go for it. And as I said, it should form part of the record and it should be part of the charge sheet. This is governed by, or this is with the case of the Chabalala, then you'll see in your notes. If then the court on application refuses to compel the state to deliver such, then where the state also refuses to comply, then the accused can apply for to the High Court for a mandamus. Then as that, then your client will then be charges against your client will then be removed. So Section 88 as well deals with the automatic cure of defect in the charge. And then, like for instance, on Thursday, I had a part heard whereby my client was facing a charge of housebreaking with intent to steal and theft. And during the trial, or the charge sheet read that he broke into and entered into this person's house and stole cables, taps, and plugs. Then during his examination in chief, then the complainant now say, no, I found him busy unscrewing the doors of the cabinets, like the wardrobes. And it was like, oh, but this evidence is new. This was never even at any stage said. And okay, I cross-examined him about it, and the court, instead of finding him guilty of attempted of housebreaking with intent to steal, then the court erred and said that the court found him guilty of attempted theft of doors of cabinets, of which the client was not charged with that, of which it was a very, very serious irregularity on the part of the court, whereby the court ended up now being the referee as well as the player in its own game. However, please take notice of things like that and be able to pinpoint any irregularity that you can then help your client with. Like now, we are in the process of appealing both the sentence as well as the conviction, because we are of the view that my client would not have then been found guilty of same. So let's then proceed with the joinder. As I said, that if there are multiple before I go to that, but I did speak to the automatic cure of defects in the charge sheet as per section 88, and then that as well. And then where, as I said to you, that the client could not then be found of any other offense which could not have then been charged off. That is the example that I gave you of what happened to me on Thursday in court. So now we are proceeding with joinder of several accused. Now, if there are more than one person who participated in the commission of the offense, they can then be joined together and stand one trial. If there is so-and-so and his friend or whoever, then all these people can be joined together in one trial. Or I steal, an example, someone steals something and then this was sold to X then takes that thing and sell it to Y and whatever. All these are accessories after the fact, meaning they are participants in receiving the property. All those people can be implicated in the same offense and they can be tried together. Then look out in your study guides in respect of the Naidu case. And then, as I said, furthermore, if separate offenses committed at the same time, at the same place, the evidence that is admissible will be against one person other than the other one, then it will depend if whether the prosecution what will the prosecution like to do? Would the prosecution decide to join all of them together, or the prosecution would like to see whoever they have the stronger evidence against the other one? But on this one, it's very risky on the part of the state to play such game, because if I'm the one, the state is proceeding, I'm going to point out to my co-accused, but no, it's not me who did that, it's so and so. It's so advisable that all of them are brought together and they are tried together, and everything, whoever will place his case before the honorable court. So please take note of whatever that will then happen in terms of what has to happen in terms of the joinder of charges, as well as a separation of charges. And there is a book by Carl Lewis, L.G. Delaray, J.H., and Vivier A.M., which is called Criminal Court Practice and Procedure, the first edition. I wanted to upload some of the examples they have used with regard to the charge sheet. However, due to time constraints, because I came back from court a bit late, but I will see to it that will then be forwarded to you. This will be very good for you guys to see as to examples of charge sheets. And I've also as well provided some information with regard to the Shabalala case, of which it deals with the access as well to the police docket, as well as relevant statements that needs to be entertained. And furthermore, when it comes to indictments, so as I indicated to you that indictments, they are mainly in the High Court. So the reason why is that is because the High Court is of a higher nature than the lower courts. But basically, the criminal procedure is the same. Whether in the High Court, in the regional court, the offense is the offense are the same. So I don't know if you guys have any questions with regard to the charge sheets as well as indictments. So basically, they are the same. It's just different court levels. Any questions?
Yes, ma'am. I wanted to find out whether during a trial, can the complainant or the prosecutor bring in new information that was not given to the accused during the time when he was finished with the docket in preparation of the trial?
That information will be inadmissible.
It will be inadmissible.
I think it's a clear example as to what happened to my case on Thursday, because that information about the doors of the wardrobes or the cabinets and the knife my client was in possession of was nowhere in the docket. Neither of the witnesses mentioned anything about that. Then it only came about during his evidence in chief. So you can see that he amended the evidence while during trial, trying to make his case look stronger. So such evidence should be admissible, and that's what I, even during my closing argument, bring it to the court's attention to then say such information should be disregarded. And what I did was, in terms of that, I took his statement, that his A1 statement that he provided to the police, and I laid the basis of my statement so that I can question him, because there was a discrepancy of what he said in court to now to then what he wrote all about. And from there, you hand that statement as an exhibit, and then that is in relation to previous inconsistent statement. And this is very, very, very important, because now the court can then see that this person is not telling the truth. He is amending his version as it comes. Because should this be brought to the state's attention before the trial proceeded, the state would have then brought it to us to then say, ma'am, we are going to amend the charge sheet so that it can include the theft of cabinet doors. So do you see how it is? So people change their version during their testimony.
Yes, and then lastly, I want to find out what happens in a case whereby a complainant has, for instance, written down two, what do you call it? When
different statements.
Yes, different statement, but it is the same case. Yes. Let's say for a complainant goes to he goes to the police station to open a case, and
Yes.
then that complainant, he writes a statement.
Yes.
And then upon investigation, the complainant writes another statement, but
Yes.
those statements somewhere along the line they are contradictory. So during the trial, which statement is going to hold water? Can the accused question both statements? Are they both admissible in a sense of saying that the complainant said 1, 2, 3, 4, but in another statement it says 1, 2, 3, 4, or only one statement is going to be used?
The court will make a discretion, but on that one, you are going to then bring it to the court's attention to test the credibility of this witness, because it cannot be that on the same set of facts, there are more than one versions. What normally happens during investigations, the prosecutor will need clarity on certain aspects to the IO. So that is when they will go and visit the complainant again to say, but what happened? And they take another statement, but then forgetting that he or she has already made a statement in previously. And that statement totally differs, or even not totally in some material aspects, but then you bring it to the court's attention and you lay the basis of your statements. And don't forget, very important, that you request both statements to be handed in as exhibits so that the court can then look. But I'm faced with two different versions, which one then to believe? Because don't forget, the onus is not on you to prove anything. Yes, your job is to create doubt on the mind of the court that your client committed this offense. So should it then come out to be then that the court doesn't know which of the two versions to believe, then your client will be acquitted. But as I say, don't forget to lay the basis of your statement. By laying the basis of your statement, you ask questions such as, ma'am or sir, did you make a statement to the police? Was the incident still fresh in your memory? Did you write the statement yourself, or was it written down for you? Did you read it back, or was it read it back? But you were fine with the contents thereof. You attach your signature, then you show it to him. Is this your signature? Then from the, yeah, this is my signature. This was still fresh in your memory, and you lay that. This was commissioned in your presence. You were happy. Yes. Then you ask the court, can I proceed now with cross-examining him on that? Then once the court allows you to cross-examine him on that statement, then, but why now in examination in chief you say this? But let's read paragraph and read it yourself. Because if you don't read it yourself, he might read it in a way that it might lose the context that you want. So read it so that the court can get it clear as to what is it that you want to highlight.
Okay, thank you.
Yes. May I just ask a more personal question? And it's,
cross-examine the complainant, or it is the representative who's going to cross-examine the complainant on behalf of the accused, or the accused can personally cross-examine the complainant?
During trial, it depends. Is your client represented? If your client is legally represented by you, the client would have given you proper instructions as to how to go about the matter. You are the one who's going to cross-examine the witness on behalf of your client. And please make sure that before the witness is excused, request the court to approach your client to then say, did I canvass everything? Is everything set? Were you happy with that? Or is there something that you want me to ask him further? Then he will say. If there's nothing, then you then say no further questions, and then the witness can be excused. So if the client is legally represented, he or she, you are the one who will then be able to ask questions on his behalf. So the only time the witness asks questions is when the witness is unrepresented. However, the court has a duty to assist such unrepresented accused person to see that his rights are not infringed.
Okay, thank you.
Okay, yes. May I ask a question?
Yes.
I take it that you are appearing on behalf of all your clients
yes.
as an attorney, and even in the High Court. So this is not about briefing counsel to appear or instructing counsel to appear. So you have the right to appear in the High Court as an attorney, and that's how you are representing your clients. Am I right?
Yes. Yes.
All right.
Yes.
So one doesn't have to be an advocate to do that.
No. Yes. But you must be someone who has more than 3 years of practicing experience, or you would have done advanced criminal litigation course. Normally it's been offered by the Black Lawyers BLA.
Yeah.
Yes. So you must have right of appearance in the High Court. Then you can then be able to appear.
Doesn't one obtain right of appearance immediately after writing board exam and being admitted?
No. Once you pass your board exams, and then you are admitted as an attorney. But just go through the Legal Practice Act rules now, and to be exactly. But what I know is that you can then be able, but once you attain, I think, 3 years of post-admission experience.
Oh, okay.
Yes.
Hello, madam.
Yes.
Yeah, thank you. But in the future, maybe we must try to differentiate between administrative matters and the questions for the content of this course. The previous caller or speaker was more on admin matters, which sometimes confuses us as we try to concentrate on the content of this module. But then how we let that go by default. So what I want to ask now is, suppose I'm a prosecutor.
Yes.
And the accused did not make any statement since he has nothing to prove, but it's the state which must prove guilt beyond any reasonable doubt. And as the trial is continued, along the way, a new evidence is discovered. As a prosecutor, am I not allowed to apply to slot in that a new evidence? Or how do I go about that? I'm a prosecutor, and then along the trial, a new evidence has been discovered to substantiate my case.
Yes. But then now, in that instance, there's a stopping of prosecution, but you have to get a certificate from the NDPP as to why you want the prosecution to stop, because it could not have then been to then say that you are the prosecutor who have all along been handling this matter. Then all of a sudden you consulted with your clients then all of a sudden new evidence pop up that you did not know of. And should it then be, you would, prior to the matter proceeding, advise your client as to the situation as how to handle with same. But should the client then insist to say that I will then bring it up to the court's attention, the defense has a right to object to such evidence being led in this court, as that would have then amount to sabotage to the defense case.
But it's allowed that I can apply to slot that new information. Suppose it's more relevant. Let me give you an example. Along the, in the evidence filed, you said, we said, or you also agreed that you had a child with Mr. X during your marriage. But as time goes on, when we study these things, we found that this child was born outside a marriage. They say maybe you said the child was born in August while you're still with this man, but only to find that the child was born in September when we were out of this marriage. And then we have a proof of that. But initially, when you mentioned all these things, you never said this child was born outside the marriage.
That is why there's something called, as part of the procedure, pre-trial meeting, pre-trial conference, so that we can eliminate things that we are going to not, that are not in dispute. And then we are only going to try for things that are in dispute. So during that process, definitely this information would have then cropped up. And if one is not malicious to the other party, you would bring it up to them to say, but we have this new information that sufficed. Then if the trial hasn't started yet, the state won't proceed with the matter pending the investigations of this new evidence. But then should it then be, then the prosecution will then bring an application for the stop of prosecuting, but it's another process. The NDPP is involved, and it might take ages for the outcome to crop up.
Okay.
Yes. Any other question? Because I see our time is up.
Yeah, before you close, maybe to go back onto that administrative matter tomorrow, when you come back, can you please assist us based on the questions which were asked by the previous speaker about the issues of admission and appearance? Because sometimes we study in isolation and then we miss some of this information. Like after this law school is board exam, what next? Yeah, I think we would like to have that kind of information. Please assist us if you can.
I'll try my best to do that, even though it's not part of the criminal procedure, but just for issue of highlighting and trying to welcome more people into the profession. I will try my best to get more information with regard to that. And before we start with the lecture, then I think that's what we will then try to focus on. Then from there we start with the day's lecture. And thanks for your attendance. Thanks. Oh, okay. Yes.
Last question regarding the content of today.
Yes.
Can complainant be a witness to his or her friends in a similar case, not the same, but similar case?
But yes, whoever can, but that would not be heard by the same presiding officer, because that presiding officer would have knowledge to the set of facts. So which means the other matter will be heard here, then the other matter will be heard to another court, which means then the matter will then be transferred. I can give you an example. I had a matter somewhere last month, sorry, whereby these people open cases for one another. They emanate from the same set of facts. So this other one has already been proceeding. We even set the trial date. Then the lady said, but I have my case, and my case is not proceeding about the same person, like both parties are the same in both instances. So we kept one here that has been on the roll for long, and then we transferred another one to a different court where it will be tried by a neutral person who doesn't know the set of facts.
Okay, yeah, sorry, ma'am. Can I just give you an example? There was
Yes.
a matter which I actually saw where parties opened a case against an individual.
Yes.
And witness, then they had a witness to say this person came to us to say therefore this is, so that person advised them. Now, the very same person who was a witness also opened a case against the very same person.
Yes.
Now, then a trial date has been set, which is going to the High Court, that the case is going to be heard by one judge. So in other words, those initial complainants, they'll state their case, they'll finish with that one, same judge. After that, the same person who was a witness also is going to state her case as well on the same accused.
But then now, in such incident, that's why I say, where's the interest of justice there? You understand? So that is why should something like this come up, one of the matters must then be transferred to another court and be heard by someone neutral. Not by the same presiding officer, because that won't be fair. He knows the story. He has already made his decision as to which version to believe. So when then another one comes, same set of facts, same people, where will be the inquisitorial nature of our legal system then be? That is why I say that would not be fair to any of the parties. So for best result, if something like this, one of the matters is transferred somewhere to be tried in another court by someone neutral, totally different, and whoever will apply his or her mind, and justice will be done. Same applies to this side, same, that will be the case.
Thank you.
Pleasure. And I would like to still up.
I missed your name again.
Pardon?
Sir, I missed your name. I missed your name in the beginning.
Oh, my name is Edna Piti.
Oh, Piti.
Yes. I'm a practicing attorney at the University of Pretoria Law Clinic.
Okay.
Yes. But then thanks for your attendance, and thanks for bearing with the technicality glitches that we have earlier when we started, and we'll see to it that tomorrow such thing does not happen again. Thank you very much. Have a lovely evening.
Thank you, madam.
Pleasure.
Thank you, ma'am. Bye.
Bye.
Thank you. Bye-bye.
Thank you. Goodbye.
Bye.
Bye.